Hello, this is Matt on the Moon Family Sedan channel. There's a comment from attorney Jeremy Hogan towards the bottom of your screen in which he highlights that there's a major issue that, frankly, up to this point at least, really hasn't been so heavily discussed, but could be of extreme consequence as it pertains specifically to the future of the entire crypto asset class, and from a regulatory perspective. And as far as why this, at least to this point, hasn't been a bigger deal in the Ripple case, I have an idea of that. And in fact, here, let's just actually get to that now, right at the outset of the video. So here's what attorney Jeremy Hogan said. He wrote on Twitter, "The major questions doctrine is going to be a major issue in crypto litigation. It's only recently come to the fore, and so was not available for Ripple in its case, but for Coinbase and Binance, yes." And so I'd love to pick attorney Hogan's brain a little bit more on why he says not available for Ripple, because I've talked a little bit about the major questions doctrine on the channel, but it's been a long time, actually, I think, anyway. I can't remember the last time I brought it up, so it must have been. And, you know, in terms of not being available to Ripple, I just kind of wonder if we get to a point where there is an appeal in the case, wouldn't that almost certainly be brought up? And I'll get into right at the outset of the video like what the major questions doctrine is. But once I go through what the definition of it is, you're going to sit there, scratch your head even further, and just kind of maybe doing a little bit of like audible sign and face palming and all that crap and eye rolling, because what's happening right now with crypto perfectly falls in to this concept of the major questions doctrine. And as a result, the SEC shouldn't be doing a damn thing that they're doing. But anyway, before going further, though, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So what was attorney Jeremy Hogan talking about there? Well, what he was sharing was in response to what I'm going to share with you right now. There was a podcast with Frank Chaparro, and he writes for the Block. Here you can see editor at large at the Block, and he interviewed J.W. Verrett. Now, J.W. Verrett, among other things, used to work closely with Gary Gensler. No, he wasn't an employee there. He was on an advisory committee for the SEC, and so he had very close interactions with Gensler, and he's been highly critical of Gary Gensler and the way that he's been approaching things. And J.W. Verrett currently is an associate professor of law at George Mason. So there's this podcast, and there's a clip of it shared by Frank Chaparro. And Frank Chaparro wrote the following. J.W. Verrett joined The Scoop, so that's the podcast, to explain the importance of the major questions doctrine and how it might apply to the SEC's suits against Binance and Coinbase. It may take years, but courts could determine that regulating crypto might fall outside the agency's jurisdiction. I hope you enjoy the show. And so this relevant portion here, I actually did take a moment to transcribe. And by the end of this, I think you're going to see that the way that the SEC is approaching this, if you factor in the major questions doctrine, which does seem to be like what the go-to should be today, the SEC just doesn't have a leg to stand with. This is just another reason that the SEC's disgusting jurisdictional overreach is ultimately going to fall apart. That's what I believe is most likely to happen. And so here's a quote, and I transcribed this myself directly from J.W. Verrett. He said the following. The idea so Frank Chaparro first asked the question, quote, "So walk us through the importance of the major questions doctrine." And here's what J.W. Verrett said. And that's him on the screen right there. J.W. Verrett says, "The idea behind it is if Congress has not given you specific authority to regulate a thing as an agency, and you're seeking to regulate it, if it involves a major question of national, economic, or political importance, then you need to get authorization from Congress before you do anything." So pause right there. When it comes to crypto specifically, doesn't it easily, unquestionably, irrefutably fall into such a category? What could be more? When was the last time there was even a new asset class created? I can't remember. I actually did research that some years ago. I just haven't thought about it in a while. It's been like hundreds of years, I think, of him research. I'd have to Google it again. It's been a hot minute. Let's just say that. It's been a hot minute. And so you're seeing 14 years now this asset class has existed. So it's a little baby asset class. And it's worth over $1 trillion now, so not a huge asset class. It would balloon to $3 trillion a couple years ago. It's probably going to be worth tens of trillions in the future. Obviously, it's being adopted globally. It's not just a United States-based thing. And so if the United States, even if it were to successfully outlaw it completely in the United States, which isn't in the cards, just don't get me wrong, just a hypothetical. Even if they were able to do that, it wouldn't go away. So you'd be talking about a major economic impact, and if the United States actually could do that, and they can't, but even if they could or would, that would be of substantial economic concern. So when you're talking about the major questions doctrine, as cited here by J.W. Barrett, if there is something that is of that level of importance, national economic or political importance, and here it's clearly national economic importance, then you have to go to Congress, period. That's what this is. And then he continues. A couple of examples where it's been used. A case where the FDA says, you know what? We're going to regulate cigarettes because, let's face it, nicotine is a drug. We have the authority to regulate drugs, and so it works. And the Supreme Court said, nope, that's not what they meant by drugs. They didn't mean nicotine, and they didn't mean cigarettes. So you don't have the authority to regulate cigarettes. Now, folks, think about this. So that's a real world example of where the major questions doctrine came into play, and that is nowhere near the level of economic importance that crypto is, and it still was in play there, just for the FDA and cigarettes. The FDA got smacked down. Crypto is unquestionably of greater economic consequence. Are you kidding me? So that's why if you look at this, it's just another thing where, and of course now you have to let this play out over time, but it's a real thing here. And then J.W. Barrett continues. He says, after stating, again, they didn't mean cigarettes, so you don't have the authority to regulate cigarettes. All that sounds a lot like the Howey test, an application to digital assets that live entirely on a decentralized blockchain. Probably wouldn't see a judge weigh in on that question until at least, Second Circuit, or maybe even SCOTUS, which of course is Supreme Court of the United States, which would be a long way away. But it's one of the things that looms over these cases without a doubt. And so again, if it weren't enough already in the SEC v. Ripple case that there's no investment contract, if that weren't enough, and then if it weren't enough that when you apply the Howey test, XRP doesn't pass it, you can still get to this point where if you're talking about the major question doctrine, you would think this would still destroy it. Now, admittedly, I don't have clarity on why Attorney Hogan said that this isn't something for Ripple. I mean, it was on the screen, however it was worded. My understanding was that it still could be just on a higher level. So maybe I'm missing. I'm not the attorney, so Attorney Hogan's the whiz. So I'm not to take anything away from what he said, but I'm just saying that previously my understanding was that if you get to a higher level court, something like this could have been brought up even for Ripple if we get to that point. Maybe it can't for some reason, unbeknownst to me. But either way, he's stating here that for other crypto-related cases like Coinbase or Binance, yes, absolutely, go to the major questions doctrine. And it is that consequential. And that's why it's just repulsive what the SEC is doing here. And so again, this is something that I haven't talked about on the channel in a very long time, and it was so artfully fleshed out that the concept was by J.W. Barrett and highlighted by Attorney Hogan here. I thought, yep, let's take a few minutes to talk about this. Kind of break that down a little bit. I'm not a financial advisor. You should not buy or sell anything because if anything I say are right, that would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.